Well, you made it to OJ. Let's get our YouTube chat in line where it should be. There we go. I believe we should get to the end of this today, of him. I think. I'm not 100% sure because it doesn't really say. But we should get to the end of this and not into any Furman issues. That's coming really soon, though.
Who collected those items, 303, 304, and 305? And I'm referring to collecting the bloodstains. Excuse me, objection, Your Honor. Speaking objection. I'm sorry?
Proceed.
I don't recall who collected them out of the Bronco itself.
So you don't recall who collected them on June 14th?
No.
Who typed them?
They were typed by Colin Yamauchi on the 15th of June.
What were the results by Mr. Yamauchi from items 303, 304, and 305?
303?
303, 304,
I'm sorry, I thought you were
305.
talking about the earlier items, 23, 25. Okay.
I'm sorry, you thought when I said
303.
You thought I said 23 and 25?
I'm sorry, let me back up. The items 303, those were collected in those were the items that were later collected from the Bronco console. So those were the items that were collected at a later date.
When were they collected?
In, I believe it was in July. I don't recall the exact date.
It's actually in August, isn't it?
Or
Dr.
August,
Davies?
yes, July or August.
So these three samples, 303, 304, and 305, were not collected in June of 1994.
No, they were collected in July.
They were
Or
collected-
August, excuse me.
They were collected over 2 months later, weren't they?
They were.
You do not recall who collected those samples.
Not the individual.
All right. What can you tell us about the sequence of events following
I'm
their...
sorry, I do recall who collected them, Colin Yamauchi.
Is it your testimony that Colin Yamauchi collected the stains from the console 303, 304, and 305?
I am not absolutely sure, but I think that is who did that. I don't have the notes with me.
Dr. Gerdes, isn't it important to know who collected these items in view of your testimony about the potential of cross-contamination?
Not in my opinion, and basically it's important how they were collected, not who collected them.
Isn't it true Michelle Kessler collected those samples?
That may be.
In your opinion, that makes no difference?
It makes, I have observed the testimony of each of these individuals on their procedures as to how they collect items. In my opinion, none of the individuals are collecting these in a manner that a microbiologist would consider safe, and therefore I don't recall the details frequently on who did it. They're all equally risky.
So it's your testimony that all of the individuals in this case and who have been involved in collecting evidence are all risky, as you've used the term?
In terms of what they've described as their collection methods at the crime scene, yes.
As far as 303, 304, and 305, what are the sequence of events after their collection?
Okay, those items were sent to the Department of Justice after being processed at the LAPD. And they were received there on September 26th.
Were these samples typed by the Los Angeles Police Department?
No,
Did they have DNA extracted by the Los Angeles Police Department?
no.
Were they processed as far as any steps in preparation to extract DNA, for instance, in the serology section of the Los Angeles Police Department?
They were processed in terms of bindling and packaging.
Now, those samples were then typed, correct, by the Department of Justice?
Correct.
All right, Your Honor, I have a slide actually in the form of a copy to place on the Elmo that I'd ask be marked as the People's Next Exhibit in order, a copy of which I provided to the defense.
565.
565.
May I step down, Your Honor?
Yes. How's your water supply?
All right, Dr. Gerdes, perhaps this item can be described as a title DNA testing of items 303, 304, 305, Bronco console?
Yes.
Is this something known as a flow chart?
Yes, I think that would be a good description, flowchart. Now, the first box to the left, Dr. Gerdes, describes Bronco console removed during search. Is that correct?
Yes.
With the date of August 26, 1994?
Yes.
And to your, or from your review of the records, does that appear to be an accurate description of what occurred on that date?
Yes.
The flowchart then has a second box to the right labeled September 1, 94. And inside that box, swatches made from console and serology, correct?
Yes.
And does that in fact
Papa,
describe
you
accurately
brewed
what occurred
coffee?
with
Good
regard to items
job.
303, 304, and 305?
I believe that does, yes.
Your only hesitation, is that right, is just as to the date?
That's right. I didn't remember the date.
The next box then shows swatches sent to Department of Justice 9/26/94. Is that right?
I don't recall the date exactly, but I believe I just read that off, so yes.
And as far as
That's what I just said, yes.
you know, that's accurate.
Yes.
And then the next box shows 11/22/94. Number 305 returned to LAPD.
Correct.
Had the Department of Justice done anything with regard to item number 305 as of November 22nd, 1994?
I'd have to check my notes, but...
All right, would you please, if that would refresh your memory?
Approach for a minute or something. On this exhibit? What? You have to discuss with the court board, please.
Item 305 from the LAPD was received by...
All right, Dr. Gerdes, you're going to have to tell the jury.
All right, excuse me. According to the report from Department of Justice, they received that on September 7th, item 305.
Dr. Gerdes, are you having a little trouble finding some of these details in your notes about
Well,
the I'm sorry.
There's a
About-
tremendous amount of data
Doctor?
here, and I apologize to the court, but it's a tremendous amount of data, and it's hard to be able to locate these in a short period of time.
All right, Dr. Gerdes, is it fair to say that you're having some difficulty retrieving some of the information about the history of these three samples? Is that fair?
I think as far as the exact dates and that sort of thing, yes. As far as the general history, no.
Would it be fair to say that the vast majority of the $30,000 that your laboratory has billed in this case, or will bill, was spent looking at the validation studies by the Los Angeles Police Department and not the specific facts and acts in this case?
I don't think that would be fair to say, no.
With regard to item number 305, and it's your testimony that the swatches were sent to the Department of Justice on what day?
September 7th. On the Department of Justice report, it says that LAPD item 305, which they renamed DNA 30, was received on September 7th, 1994 by Mr. Stevens. And I have a slot-bot result on that item on 9/23/94 by Renee Montgomery, and a D1S80 result of DNA 30 on 10/17/94.
All right. As far as the date, then, you believe instead of September 26th, it should be September 1st?
September 7th.
7th, I'm sorry. As far as that item, after it was received at the Department of Justice, and you just described some DNA typing steps that were taken with regard to 305, correct?
Correct.
Did it or was it later returned, the remaining sample from 305, to the Los Angeles Police Department? As is reflected in the next box on the flowchart.
I believe some of it was, yes.
Did there also come a time, and the flowchart makes comes down, makes a left turn, and starts a second row, correct?
Yes, I'll have to get down.
If that would be easier, that's fine.
Hi, Terry.
And what's noted as the date, March 9th, 1995, number 305 returned to DOJ. Is that right?
Yes,
And is that, in fact, an accurate description of what occurred?
I believe so.
There's then a notation on the same date that all items were returned to LAPD. Is that correct?
Sometime they did that after the date.
Okay. You're just not sure of the date of March 9th, but in fact, 303, 304, and 305 were returned to the Los Angeles Police Department, correct?
Correct.
Your Honor, would this be an appropriate time to stop on the chart?
Yes. All right, ladies and gentlemen, let me ask you, I need to take up an issue out of your presence. Would you please step into the jury room and we'll summon you out shortly?
They're gonna fight, guys. They're gonna fight.
The record should reflect all the jurors have withdrawn from the courtroom. Counsel, my understanding is that there is an objection by the defense to mention of the combined swatches and RFLP testing that is being conducted by the Department of Justice, and that objection is based upon the fact that the defense has all along asked for permission for access to those swatches to do its own testing, that these swatches have continuously been in the possession of the prosecution.
Judge, you're not allowed to bring a knife in, a concealed knife into the courtroom. Judge, you're not allowed to do that. You can't carry weapons into a courtroom. There's a murderer sitting right in front of you that stabbed people with a knife.
Or their testing agencies, and not available to the defense for their own testing, that months ago, and I don't recollect the specific date, the court gave the prosecution permission to continue their testing as to these items 303, 304, and 305, the Bronco console swatches that were taken in August. The court gave permission to the prosecution to combine those swatches and to attempt to conduct RFLP testing, and that it was anticipated that because of the low amount of DNA that was there, that this process would likely take a considerable period of time. My understanding is that there is a defense objection because the Department of Justice, despite the court's permission, did not actually commence this testing for a significant period of time, approaching 2 months, and that this result, the RFLP results, are therefore not appropriate to be presented by the prosecution in their case in chief. One, because obviously they have concluded their case in chief, and two, because of the unexplained and unjustified delay in the starting of the RFLP testing. Is that my understanding of your argument?
Well, that's the beginning of it, but the full thrust of it is this, and it's a simple one I think we can resolve at the moment, and that is that whether or not this evidence, and first of all, there's no results reported, so we're talking only about a process that's ongoing. Whether or not these results would be admissible in the prosecution's rebuttal case is a question which I'm certain the court had agreed and the parties had agreed would be dealt with at that time. In fact, I think your words were, this is a problem I don't have to deal with yet. And the results aren't even here yet. It was my mistake that yesterday, this was not, they gave us copies, Xerox copies of all the charts except for these last two flow charts. And when I looked at the flow charts, I actually pointed out to Mr. Harmon that on another one concerning the carpet, they'd made a mistake on a date. But I did not notice these last two boxes because when my eyes glazed over it, I thought it was just the history of the sample. I didn't see these last two boxes, so that was my mistake. And I didn't realize, therefore, that they were going to try to raise the fact that there was RFLP testing ongoing. Now, this witness, frankly, there's no documentation, no written documentation of this. In other words, the testing that's ongoing, and he has no knowledge of it, obviously, because we have no reported results. So I believe that it is improper at this time for the prosecution to ask a question of this witness, well, which is what they intend to do, well, if there were an RFLP result on the combined Bronco stains, would that change your opinion with respect to these samples? Because I don't think there's been any ruling, and there shouldn't be a ruling until we reach the point where they try to offer a rebuttal and have results.
Likely to be, well, because these were PCR swatches first, any contamination that's attendant to those, and these swatches are inherently suspect because they were left in the environment until August. I mean, isn't that a pretty simple answer?
Well, no, because what, as the end of my direct examination indicated, and as what's going to be going on, I'm certain in the rest of Mr. Clark's cross-examination, is that there are differences as to each individual item. I anticipate, and well, on direct examination, Dr. Gerdes indicated that he did not have a quarrel and did not believe cross-contamination could be a problem with a whole series of RFLP results in this case for two reasons. Number one, the amount of DNA involved in the RFLP test, approaching 100 nanograms, was so high that cross-contamination was not a likely explanation. And number two, in terms of the history of the samples, those samples were not processed in the presence of a reference sample from the person or persons who the typing came back. And Dr. Gerdes' testimony on the RFLP and cross-contamination is limited to number 52, handled in the evidence processing room.
You're anticipating that Mr. Clark is going to say, now, if these results were corroborated by RFLP, then you would have the same non-objection. Is that what you're anticipating?
I'm anticipating he's going to ask him, if these results were corroborated by an RFLP, would you... Right. And the point is we don't have the data from that RFLP. We haven't seen it. And so no scientific evaluation can be made. That's number one. So it's an unfair question in that respect. And number two, we have a whole argument here about whether that would be proper rebuttal given the nature of this testimony, which is not an issue that should be broached now. The only reason it's even being broached now, frankly, was my inadvertence in seeing a box on this chart that says RFLP testing ongoing today. And even if the court would allow him to ask a question about that box, he shouldn't be able to ask any more questions about test results that have not yet been reported, that have not yet been performed. It's totally speculative, and frankly, it's dirty pool. My mistake for not observing that box, but it violates
Sanctions.
everything we'd agreed to previously.
Well, counsel, let's, it's not dirty pool if it was given to you and you had the opportunity to
My
see it.
mistake on that. I'm just saying that I didn't
All right.
notice it, and I'm confident that
I'm not tolerating any more of this stuff.
Which stuff?
Disparagement of the other side.
Oh.
All right, so let's not do that.
Your Honor, my apologies for that. I think my record is pretty clean on that. I don't do that.
All right, but the thing is, it's not dirty pool if you show it.
No, I missed that. What I'm saying is, I missed it. I should have noted it because plainly it was something that we'd agreed to take up at
Okay.
another time.
Mr. Harmon.
We had agreed to take it up at another time, and they've raised the specter of it, I think, 2 weeks ago, and we've been willing to do it whenever they wanted to bring it up. I think the court recalls the context of, Mr. Scheck always says, well, we're going to bring this up, we're going to bring this up.
All right, Mr. Harmon, let me
Sure.
stop you.
I'm sorry, Your Honor.
First of all, good morning.
Good morning.
Secondly, what is the status of the RFLP testing?
I probably should have told you that.
That would be nice to know.
Apologize. We have now produced a 3-probe RFLP match, which shows a mixture which is consistent with the blood of the defendant, Mr. Simpson, and the blood of Ronald Goldman. And however much time permits, we'll continue to probe it, and if suddenly we exclude that on the 4th or 5th probe, that'll be fine, but that's highly unlikely. So that's what they fear, the other shoe. I can address the timing. I can address any of the issues there. It sounds like the biggest complaint right now is we don't have to deal with it yet. And I can't speak for Mr. Clark. This is a little awkward. I'm arguing this issue in the context of his witness, but the intention only was to ask a hypothetical.
Is that the
which is
witness
based on
sitting
what
behind?
in fact has been done. And I just need
Give
to
me the
clarify,
camera.
when Mr. Scheck says we haven't seen it, he's obviously excluding the guy who's never been in the blue chair, Dr. Blake, because he's seen all this stuff. He's had access to it. I don't know if he's seen the 3rd probe. He had an appointment 2 days ago, and he couldn't show. But he knows these results. He's had access to it. If he's failed to communicate with them, we know he doesn't talk to Dr. Gerdes very much, so that's not our fault. They've known what these results are. They know the instant they're available, and so I don't think that's a legitimate legal complaint, and I don't think that's a sincere statement because it's not, in fact, what's going on with this case. We do have to deal with it. They've wanted to deal with it. As you recall, it's come up a couple of times, and as recently as I think last Wednesday, Ms. Clark informed me that we were going to do it Thursday morning, and I spent hours on the phone with Mr. Sims that night working out the chronology of it, and then for whatever reason they chose not to bring it up. I think this is a tactical decision, so I can address timing. I'd like to clarify that they have had access to whatever remains of those since March, because we proceeded with the court's permission with the combination of those samples back in March, and I can't tell you right now what remains, but I know I'm almost positive at least one swatch has always remained.
Right there,
in
right there, right
305.
there.
I'm not certain on that.
Oh,
So
we
the
just
idea that
sat
they've been
back.
denied access is
So, beside the bailiff, is that the witness that's on the stand right now? Wait till he leans forward again.
it's not true.
He shouldn't be listening to this.
It's not the reality. It's not the case. I can explain the whole chronology, but that doesn't seem to be the basis for the objection. The objection seems to be we don't have to deal with it yet because it's not proper for rebuttal, and we say, well, we just want to ask a hypothetical that's based on the reality of it, so we don't have to drag Dr. Gerdes back here and confront him with it. So I think I've addressed the specific basis for their objection today. I'd be happy to
I'm gonna
discuss
go
any
start
of the
my
other
car real
issues
quick.
that I
I'll be
thought
right
were
back
germane.
before I
I
leave.
don't see that there's a need to. We would just like to ask them because obviously they seem to have conceded that the stuff in the console may have been, may have been from some phantom, but it has nothing to do with this case. So those results, they seem to have conceded the legitimacy, and there's been absolutely no discussion by Dr. Gerdes on a technical basis of any complaints about what's there, and in fact the results are corroborative, totally corroborative of the relative intensities of the mixtures.
No, he's testified to his concerns that those samples were left out in the environment and unprotected, and he's expressed a lot of concerns about that, about the Broncos.
I don't recall them being specific to those stains.
Well, that
but-
pretty much covers it, wouldn't you say?
Sure. Unless somebody planted them on August 25th and then they weren't out there very long. So I guess that's the alternative theories that still persist till today.
Yeah, but then there'd be EDTA in it, wouldn't there?
Unless, but you know where that goes. We
Okay,
could-
we've been down that road already.
yeah.
All right, Mr. Schick.
I think that the argument admits too much. They want to ask him a hypothetical question about a set of test results that haven't been reported. We don't have any quantifications on the amount of DNA in those results. The results, as Mr. Harmon indicates, are not, the testing isn't even completed. So it seems to me that it's highly improper and it ought to be dealt with at the appropriate time. I expressed concerns about this, sure, because I knew the testing was ongoing, and I don't agree with his characterization of the results, frankly, from what I've been told.
I'm going to sustain the objection to the proposed hypothetical question regarding RFLP testing at this point for this reason. I still have the concern about the delay in the starting of the testing and whether or not any of that RFLP results will be admissible before this jury. That's an issue that is yet to be resolved. The prosecution still has the ability to recall one of their expert witnesses to say, to evaluate Dr. Gerdes' testimony, that RFLP testing, given a high amount of DNA availability, will corroborate the other results. Do you agree with that? Do you agree with that with regards to this particular result, 305 from the Broncos? So they have the ability to present that evidence in an affirmative manner before the jury. So I'll sustain the objection to a proposed hypothetical question. And having said that, let's take our break for 15 at this point. All right, back on the record in the Simpson matter. All parties are again present. All right, Deputy Magnera, let's have the jury, please. And Doctor, why don't you come on up, save a little time here.
All right, hold on. Of course this happens when I go start my car.
All right, the record should reflect we've been rejoined by all the members of our jury panel. Dr. John Gerdes is on the witness stand undergoing cross-examination by Mr. Clark. Mr. Clark, you may continue.
Thank you, Your Honor. Morning again, ladies and gentlemen. Dr. Gerdes, day before yesterday, you criticized the results from the console of the Bronco, items number 30 and 31, correct?
Correct.
It's correct, is it not, that items
All right.
303, 304,
I'm gonna
and
take my daughter to
305
work.
came from the
I'll be right
same
back.
general area as items 30 and 31 on the console of the Bronco, correct?
That's correct.
It's correct, is it not, that the DNA types obtained from items 303, 304, and 305 corroborate the results from 30 and 31?
That's correct.
You didn't criticize day before yesterday or yesterday morning the PCR results obtained from items 303, 304, and 305, correct?
Sustained. Phrase the question.
Did you, yesterday or the day before, criticize their PCR results from items 303, 304, and 305?
I did.
Incidentally, with regard to these validation strips, approximately how many did you look at? And I'm referring to not the case-specific results in this case, but the LAPD PCR strips.
The validation strips, how many did I look at?
Approximately.
1,069.
So a little over
A
1,000.
little over 1,000.
You looked at each of those individual strips.
I did.
You looked at them carefully.
Yes.
You would look at, for instance, the results reported by the Los Angeles Police Department analysts in those strips.
Yes.
You would look at each of the individual strips, and you would look, well, you'd look at each of the individual strips, right?
Correct.
And you would look at each of the individual probes on each strip. Is that right?
Each of the probes, meaning the dot
Yes.
signals? Yes.
And you would look carefully at each of those individual dot locations.
Yes.
Because you were looking to see if there was no dot indicated, right?
Correct.
And you were looking to see if there was, for instance, a bright dot on a particular probe. Bright signal.
I basically only determined if I saw something as indicated on that or not. I didn't try to look at intensities.
Well, you did in fact look at intensities on each of those strips, didn't you?
No, I simply looked at whether or not there was something present there that should not. First of all, I looked at the typing result and then determined, and these are on, I assume you're talking about the known reference samples or exemplars. On those particular cases, I would simply look at the typing result and then determine if there was human DNA, extra human DNA that would indicate another type there, and that would mean any indication of a signal, faint or dark.
Well, isn't it true that with regard to all of these strips, whether they're from a known person, an evidence sample, a proficiency test, that intensity is very important to look at?
It depends on in which context.
Well, isn't you, and haven't you already described the fact that the intensity of other dots in comparison to this C dot is very important to correctly interpret results?
The C dot is important to determine if there's a minimum amount of DNA required for a typable result. But in the presence of any indication of a mixture, it no longer can be used in interpretation because in the presence of more than one contributor, the individual that has the more DNA would light up the C dot, and the individual with less DNA may or may not, but would also be observable.
Well, doctor, if you look at, let's take a proficiency test on a blood stain from a sidewalk or from wherever. Isn't the intensity of the C dot very important for an analyst to look at?
In terms of determining if there's a minimum amount of DNA, yes.
And isn't it important to compare the intensity of the C dot to any other dots that show up where there's a reaction?
It's important in terms of the determining that there's a minimum amount of DNA and whether the typable result is greater than that if one is assured that there's a single individual.
Well, doesn't the user guide stress the importance of looking at reactions or dots and comparing their intensity to the C dot?
In terms of obtaining a typable result from a single individual, yes.
So it is important.
In that context, yes.
How many dots or probe, in other words, how many different dots can there be on a sample if all the dots lit up?
Well, there would be the 1.1, 1.2, 1.3, the 2, 3, 4, the C dot, the 1.1, 1.2, 1.3 dot, and the all but 1.3. So that's, what is it, 8.
Isn't there another dot that's the 1 dot?
Yeah, excuse me, I forgot the 1.
Is that, I'm sorry, perhaps
9.
9 dots?
Yes.
If you looked at over 1,000 samples, you had to look at approximately 10,000 dots, didn't you?
Yes,
Did you look at those dots carefully?
I did.
Did you do it in any particular location?
I did it in numerous locations.
So you did it a number of different times for each sample, is that right?
I did.
So you looked, would it be fair to say you looked at, what, at least 20,000 dots? If you did them each more than once?
I believe I looked at those at least 4 times.
So you looked at least 40,000 different dots.
That's correct.
Did you use a magnifying glass or anything of that nature?
No,
Did you use any special lighting of any type?
I looked under different lighting conditions.
How long would you look at each strip?
Oh, it doesn't take that long, really, perhaps 5 or 10 seconds.
Is it your testimony that you can look at a DQ alpha typing strip and in 5 to 10 seconds interpret the results?
Yes.
Isn't it true that in interpreting a DQ alpha typing strip, you have to look if there's any reactions, and if there's reactions, you have to look at them with regard to their intensity?
Again, I think I just explained that twice.
I think we did.
Dr. Gerdes, isn't it true that to look at 40,000 different dots, that would take weeks?
I spent a lot of time on this case.
And in fact, your review of those dots, of those typing strips in the validation studies actually took months, didn't it?
Well, I didn't do it at its full time, but basically over a period of months, I looked at these, yes.
Is it your testimony that all you needed was 5 to 10 seconds to interpret each of these strips?
Or less.
Less than 5 to 10 seconds.
It doesn't take that long.
Did you also, and you've described the fact that you were keeping track of your notes in a chart form or spreadsheet or something like that?
Yes.
And you obviously would take time to do that as well, correct?
To record what I observed, yes.
And as you looked at strips the second time, the third time, and the fourth time, would you make changes to your chart?
Yes.
So you were compiling and recompiling and recompiling.
Yes.
Incidentally, when you made changes, does that mean there were mistakes that you made before that?
Not necessarily.
Were there any instances in which you found that you had made mistakes in your chart?
There were instances where there were, on the first time or in a particular light, there were faint, I guess what the DOJ would call hints, that later on I would look back and I would have to make a decision as to whether or not that was real. And basically, what I would do on the first run through is just note those areas where I had questions, and I would go back and look at those. I mean, it was never recorded as an absolute result until the final report. They were recorded as questionable. Look at this one, look at it again, go back until you finalize it.
Isn't it true that in many instances of the various notations that you made on your chart about, quote, contaminants, that those included very faint dots?
There are faint dots on, I wouldn't say many, but on a significant proportion of those, perhaps, yes.
Some of them were very hard to see, isn't that true?
Yes, and recall, most of those were recorded by the analyst, and I, as the second analyst, am at a disadvantage in that these strips fade after they dry, and so the analyst might have seen those at darker intensity than I could.
How many casework samples did you review in this study of the May 93 through August of 94 review?
There are substantially fewer casework samples.
Can you give us a number or an approximate
Approximate number would be less than 10%.
So what number would that be? Something
Less
under
than 100,
So something under 100 casework samples.
yes.
Of the number of casework samples that you looked at, how many did you determine, in your opinion, showed contamination?
I didn't include casework samples unless they were known reference samples, or the positive control, or the negative controls.
Is it your testimony that you can't determine from a casework sample whether or not there's contamination present?
That's true, because I don't know where that sample came from or what conditions it was collected, under which conditions it was collected, so it would be unfair to count those because it's not defined as having come from a single individual.
So is it true that any casework sample you cannot conclude there was contamination because you don't know the history of the sample?
It is true on those samples that are recorded as being evidence items. It's not
Samples-
true on the negative control or the extraction, or the reagent blank, or the positive control, or items that were defined as being reference samples from a given individual.
The samples tested in this case were evidence samples, correct?
Yes,
And they were known samples from known individuals.
yes,
And then there were a series of controls you previously described, correct?
that's correct.
All right, Your Honor, I have two photographs that I'd ask to be marked as next two exhibits.
566 and 67. Have you shown those to Mr. Scheck? Previously?
Ben has a copy of them, but these exact photos.
All right. Proceed.
May I approach the witness, Your Honor?
You may.
Dr. Gertie, showing you what will be, I'm sorry, People's Exhibit 566, I believe can be described as a DNA hybridization record photograph, including both the documentary material as well as a photograph of a series of strips. Is that right, Doctor?
That's correct.
And in particular, does that relate to a hybridization number 182 as to the first photograph?
It does.
As to the second photograph, which will be People's 567, does that appear to be a similar photograph relating to a hybridization record number 184?
Yes, it does.
Do those photographs appear to be accurate copies of the original documents and photographs that you saw at the Los Angeles Police Department?
If I could check for just one
Sure.
moment. Yes, they appear to be the same.
All right, then with the court's permission, I'd like to use the 15th Exhibit 566.
Yes.
Now, just while we're at abroad, and Doctor, would it be easier for you at the witness stand, or would it be easier for you to come down to see the what's projected, or to operate from the
I believe if I can operate from my photo, it'll be, if I have to go back to the table to look at my recordings, maybe that would be best here at the
That's
moment.
fine. Now, just in terms of this exhibit, People's 566, this is hybridization record number 182.
I can't read
Perhaps
the
if you could
monitor,
zoom
but
in just on the upper right-hand corner. Actually, zoom in on the very top of the document.
About the right hand.
yes, this is 182.
And this is a series of 8 strips that were run on May 6, 1994?
Yes,
And is this one of the, as we've used the term, validation studies that you looked at as part of your review?
these are some of the samples I've looked at, yes.
The analyst in this case, or at least in the instance of these 8 samples, was Colin Yamauchi,
That's correct.
and the confirming analyst was Aaron Riley.
That's correct.
Now, is it correct that none of these were casework samples?
No, that's correct.
You identified in this particular set of 8 samples, 2 samples as containing contamination. Is that right?
That's correct.
And would the
Basically, they were identified as contamination and/or DX.
and that was, in your opinion, the result, that is, these reactions of either contamination or this DX gene activity.
In this specific instance, again, these are one dot. They contain a one dot, so this is one of those cases where you can't tell.
Could you tell us, in terms of the photographs that go from top to bottom, and let's start with the first one, which would be easier to start with from your records?
In terms of which one was identified as a contaminant,
Yes.
let's start with number 2.
Okay, that would be the sample, and perhaps we can zoom in on that horizontal strip. In fact, I don't know if you can tell, Doctor, but in terms of talking about both samples, is this zooming point going to be enough to be able to describe both samples that you have offered opinions about?
Yes,
All right. Now, the second sample down is labeled off to the far right 52-2,
yes,
and the analyst noted a particular result with that sample. Is that right?
that's correct.
What did the analyst note?
A 1.2, 1.2. And then there's a notation that's difficult to read, but it says with 1.1 very faint.
Okay, is that actually written by the analyst off to the far right?
It is.
Perhaps if we could just show that off to the right of that sample, I'm sorry, by going down into the written portion, the results are actually written in. Isn't that right, Doctor?
That's correct.
I believe
You have to
right.
go to the
This
right.
would-
And is that, Dr. Gerdes, when you look at the second row down, where you have described 1.2, 1.2, and then is that with, or I'm sorry, weak 1.1?
That's correct. That's what that says.
Okay. And in your opinion, and what you have described in your chart and your summary of your findings, then that 1.1, you have offered the opinion, is either a contaminant or this DX activity.
That's correct. You can see it on the photograph. It was recorded by the analyst. It's an additional allele compared to what the analyst has recorded,
And
and,
in fa-
therefore represents, either DX or a contaminant.
And this is because you know the sample's type is a 1.2, 1.2, right? It's from a known person?
That's correct.
All right,
It's
if we
from a
could-
known, this was for proficiency testing, and that was the correct type that it should be.
All right, if we could then zoom in on the strip as we had it previously. And what I'm going to ask you to do when we reach that point, Dr. Gertis, and perhaps we can use the arrows, to actually locate the arrow next to the dot on the sample, the second sample down, where you concluded that there was an additional 1.1 contaminant or DX gene activity.
Do you want me to do that?
Well, would it,
Just-
let's see if we can just place it while you're
Okay,
there. If we
okay.
take the arrow and go to the left, or go off the screen.
It's on a monitor here still.
I think we just lost our projection. May have to do this the old-fashioned way.
Or ask the jurors to crowd around the monitor, but I don't think that will work.
I think we have lost, it appears to me that we've lost the, our large monitor unit. Matt?
Yes.
All right, how long does it take us to switch in the backup?
15
Mr. Clark, what's your pleasure?
I would prefer to continue on based on the foundation I've already laid, rather than interrupt this topic.
All right, proceed. All right, I do have a monitor here in front of juror number 1 that is still working, is that correct? Matt, how long is the cable on the monitor in front of number 1?
About 50 feet. I can move it.
It's a large monitor, it's 20-inch monitor, as I recollect. 21.
May I make a suggestion? I'll proceed if I can do it the old-fashioned way and have the witness place an arrow on the exhibit and then pass it to the jury.
Be my guest.
All right. Certainly used to doing it that way.
That's the way they do it in Oklahoma, I'm sure. You may.
All right, Dr. Gerdes, on what I believe is People's Exhibit 566. If you would, and you need perhaps you can use a fine.
Yeah,
fine
I don't
pen.
have a fine pen here.
I have a felt tip fine point with that.
Have a regular pen? Or
Regular
felt
pen's
tip would be
fine.
good, I think.
And with regard to that 1.1 allele on that second sample down, in fact, is that sample labeled 52-2?
Yes, it is.
Okay. Could you place an arrow, and if it's possible to do that without interrupting any other of the results, to point out the 1.1 dot where it's located on that sample? And would a circle around it be
That
easier?
would be fine.
Okay.
Okay.
Can you place that circle?
Yes.
Does that circle then now basically surround the dot where you detected what you believe to be either a
It-
contaminant or DX activity?
Yeah, I've circled both the number that designates it, and just to the right of that number is where this dot, very faint dot, is located.
First of all, that dot is clearly less than the C dot, correct?
It is.
And the C dot is important in the correct interpretation of samples, correct?
It's important in the correct interpretation of samples that are known not to be mixtures. Once you have any suspicion of a mixture, it is no longer used for that function.
Well, doesn't the user guide say the C dot is to be used as a guide in interpreting the presence of typable alleles?
Yes, that's what I explained earlier. If the C dot is not present, that's why this is important. If it's not there, you have too little DNA. If it is there, and you have any indication of more than the number of alleles you should have, then it's no longer of any function.
While you have that photograph, was there a second sample that you believed similarly contained a contaminant or DX activity?
Yes, there is.
Okay, would that be how far down?
2 strips down from the one we just discussed, or 52-4.
Could you circle that, a particular 1.1 dot, in
Certainly.
the same manner as the previous one? And you've done that?
I have.
For purposes of your chart, those 2 samples, as a result of that 1.1 activity, were listed as unexpected alleles, correct?
That's correct, because these are proficiency samples. The typing...
Oh, I'm sorry, objection, non-responsive, move to strike.
They're proficiency samples. The typings, expected typings are known. They're not mixtures, they're not supposed to be mixtures as they were provided. And this is an additional allele over those anticipated typing results.
Next question.
Was it listed in your chart?
It was.
If that 1.1 reaction was as a result of this DX gene, it wouldn't be a contaminant, correct?
In this case, you can't tell if it's a DX or not.
Objection,
Sustained.
non-responsive.
That's not the question, Doctor.
Doctor, if that activity in the 1.1 dot was from the DX gene, it wouldn't be a contaminant, would it?
That's correct.
If that 1.1 dot was the result of cross-hybridization because of the presence of the 1.2 allele, then that activity would not be from a contaminant, correct?
Yeah, cross-hybridization is not well known for this particular gene other than the DX phenomenon, but that's true.
So it in fact would be true that it would not be from a contaminant if it was because of cross-hybridization with the 1.2 allele.
That's another explanation for this particular allele.
And in fact, this cross-hybridization is described in the user guide, correct?
It's described in the presence of high levels of DNA, yes.
It's described in the package insert, isn't it?
Yes, it is.
And it's described in the scientific literature about DQ alpha typing.
Yes.
All right, Your Honor, at this time I'd ask that the photograph be passed to the jury.
All right, let's hand it to juror number 7. All right, Mr. Clark, would you collect that from Deputy Long, please?
Yes,
All right, let the record reflect that all the juror members have had the opportunity to review the exhibit. Mr. Clark.
Yes. Dr. Gertie's now showing you what I believe has been marked People's 567. I believe you've stated already that that appears to be another similar photograph of what was 2 hybridization records later than the previous run.
Yes.
Was that part of the same DQ alpha run by Colin Yamauchi?
Yes.
And
Same
in-
date.
And in this particular instance, you identified 2 more samples that you believed demonstrated a contaminant.
Yes, 52-20 and 52-22, which is the 4th strip down and the 6th strip down.
Okay, and you've used the identifier 52-20 to describe...
Yeah, basically you could use lane 4 and lane 6.
Okay. You concluded from that run, and again, this is a series of non-casework samples?
Yes, that's correct. They're all standards
Let's
or
start-
proficiency.
Let's start with 52-20. The actual type called by the analyst is a 1.2, comma 2.
Yes.
You agree with that typing?
Yes.
That was a correct typing?
Yes.
You also as a result of your review of all of these strips, concluded that, in your opinion, there were two other alleles present that you felt were contamination.
On that particular strip, yes.
And what alleles were those?
The 1.1 and the 1.3 are visible on that strip.
Could you then, with a pen, circle those two alleles, the 1.1 and the 1.3, that you felt were contaminants, as you did with the previous photo?
On 5220?
Yes.
Okay.
Did you do that?
I did.
Thank you. Also, on that same run, you identified another sample as containing contaminating alleles. Is that correct?
That's correct.
That was which sample?
50, well, lane, hold on. That would be lane 6,
52- number, just for the record.
52-22.
What alleles were called by the analyst?
A 1.13 with a very weak 1.2, 1.34, and a 1.3.
Okay, first of all, the type that's called by the analyst, and I may have misunderstood you. Did you say 1.1?
1.13.
All right. And then you also described the analyst made some notations about some other dots.
Yes. It's noted very weak 1.2, 1.34. That's that dot that detects all of those, and a 1.3.
Okay, just to be clear, when the analyst wrote down very weak 1.2, 3, and 4, the analyst wasn't noting that the analyst saw a very weak 1.2, a very weak 3, and a very weak 4.
No, that's one dot. That's that dot that you see all three of those on that one dot.
So the analyst was really noting, this is a dot that I saw a very weak pattern,
Correct.
not that I saw a very weak of those three individual alleles.
That's correct.
Did the analyst make any other notation?
No. Well, the 1.3, which I discussed earlier, yes.
All right. As far as your review and the opinions that you offered as a result of reviewing that strip, did you then conclude that there were contaminating alleles?
Yes, this is a standard. It should only have the two types, and it has these additional dots.
And the additional alleles were what?
They would be consistent with a 1.2 and a 1.3.
Now, those alleles, 1.2 and 1.3, were clearly less than the C dot, correct?
Yes, they are.
As far as the call on the sample by the analyst, do you agree with the call of the actual typing results?
Yes,
The typing results of 1.1 and 3 were called correctly by the analyst, is that right?
that's true.
With regard to, and you described the fact that this sample, the person actually has the 1.1 allele, correct?
Yes,
If the reaction in the 1.2, and again, the 1.2 is a very close probe to the 1.1, right?
there's a single base pair difference.
If the 1.2 reaction were as a result of cross-hybridization, it would not be a contaminant, correct?
That phenomenon is not reported to be a problem with that particular dot, but
Objection non-responsive,
theoretically,
Your
yes.
Honor. So the answer is yes?
Yes, but it's not been reported to be a problem on that dot.
When you say it's not recorded to be a problem, what do you mean?
In laboratories, the number of laboratories I've looked at, and in the literature, there's no report that the 1.2 cross-hybridizes.
Dr. Gerdes, isn't it true the scientific literature does describe cross-hybridization of all of the 1 subtypes, 1.1, 1.2, and 1.3?
As far as what's observed in laboratories, the 1.1 and the 1.3 are observed.
Objection non-responsive, Your Honor.
Sustained.
Dr. Gerdes, doesn't the scientific literature describe cross-hybridization between all 3 of the 1 subtypes, 1.1, 1.2, and 1.3?
I don't believe so.
If the 1.3 allele, and we discussed just the 1.2 at this point, correct?
That's correct.
If the 1.3 allele were from cross-hybridization, it would not be a contaminant, correct?
That's true.
All right, Your Honor, then with the court's permission, I'd like this particular photograph be passed to the jury.
Would you like me to mark those dots?
Oh, I'm sorry. Yes, please, Doctor.
Okay.
All right, Mr. Clark, would you hand that to juror number 7, please?
states the logistics.
All right, let the record reflect that I believe that's 567. Mr. Clark, that's 567?
Yes.
All right, the record should reflect that all the jurors have had the opportunity to view 567. And Mr. Clark, it's now your request that we do use the projector for the next items.
Actually, if I could have about 2 minutes with a board, then I would like to use the projector.
Well, we're missing one of the jurors now,
All
so
right.
why don't we just take a break right now? Let's take 10 minutes. Mr. You got 10 minutes to swap that out. All right. All right, let me have the jurors step back in the jury room. We're going to of our jury panel. Mr. Clark, you may continue.
Dr. Gerdes, you have conceded that if in fact a signal, such as in the photographs that have been shown to this jury, are the result of cross-hybridization, then they are not the result of contamination, correct?
Correct.
As far as the creation of your chart, and in fact there were a number of charts shown to the jury that discussed and had bars or graphs of contamination, you recall those?
I do.
In those instances in which, for instance, there is cross-hybridization instead of contamination, those charts are biased as far as the presence of contamination in the LAPD laboratory, correct?
I think we tried to explain what the degree of bias would be. And so, for instance, on the 1.1, that was 7.6% of the strips. And on the 1.3, that was 25%. So if it's biased, we attempted to explain the bias.
In other words, the way the charts are written assumes that what might be cross-contamination is contamination.
Objection. Argument is sustained.
Do those charts reflect, then, and include in those graphs of contamination incidents which may be the result of cross-hybridization?
Only for the specific case of the 1.1 allele and the 1.3 allele.
Is it then the case that what may be a graph that you show 100% of runs contaminated, that if in fact the 1.3 and 1.1 alleles are present, then those charts overstate the contamination?
I don't believe so, because the reason I analyzed it in that manner was to look at more than one strip to attempt to find a confirmation.
Does that mean, Dr. Gerdes, when you describe the 25% and the 7.6%, that your charts may overstate the contamination at the Los Angeles Police Department by over 32%?
Objection. Vague question.
Over.
Remember, those are the percentage of those specific alleles, and those are only 2 of the 6 alleles. So in terms of, if I could look at my notes.
Do you need to look at your notes for some answer, portion of this answer?
For an example, yes, for an answer. If we sum the total 1.1 plus 1.3 that could possibly be DX or cross-contamination, that could be 16.5% of those alleles.
Dr. Gerdes, what I'm asking is when you say the month of May of 1994, and you show, and I'm not trying to give an exact number for the month of May, let's just assume you have a number, whether it's 40%, 50%, or 60%. You have a bar graph that approximates that percentage, correct?
Objection. Vague as to which chart, which bar graph.
Sustained.
With regard to these graphs, there's one that describes run contamination and strip contamination for May, June, and July, correct?
Correct.
As far as that particular graph, and let's assume for May there's a certain percentage of strip contamination, whatever that is, all right?
Yes.
That figure, whatever that percentage is, does that include these 1.1 and 1.3 instances?
This stays the chart.
The
chart speaks for itself.
Are you talking about the strip chart or the run chart?
Talking about the chart that has both.
Now, on the strip chart, those would be included. On the run chart, the entire date would be evaluated with one sample versus the other so that I can confirm whether that or not, that was contamination or not.
I'm not sure you can see that from there. Perhaps if you would, could you step down?
And this is 1297, if I recollect correctly.
Yes, thank you, Your Honor. Dr. Gerdes, with regard to this particular exhibit, is this the chart that I just questioned you about as far as demonstrating for May, June, and July your opinion of contamination levels by both runs and strips?
Yes, it is.
All right, Doctor, would you just take a half step back so you're shielding the court privilege? Thank you.
And if I could, Dr. Gerdes, let's take June, where there's an indication of 33% of strips.
Excuse me, you're pointing to May.
I'm sorry, yes, you're right. Referring to May, where there appears to be a green block that includes strip contamination and/or artifacts. Is that right?
That's correct.
Does that 33% include the 1.1 alleles?
At that point, it does, yes.
Does it include the 1.3 alleles?
Yes, it does.
The 1.1 alleles can be the result of DX activity and not contamination, correct?
That's true.
The 1.3 activity can be a result of cross-hybridization under your own testimony, correct?
That's true.
33% includes both of those, doesn't it?
It does.
And in fact, if those are not from contamination, those overstate the percentage of contamination, don't they?
They would by less than 16% overall.
So it's your view that it only overstates it to a certain extent, but the chart is still correct.
If I can explain that?
Well, the question is,
No, no.
under the...
May I, may the witness explain?
No,
He
he has to answer the question. He can explain his answers on redirect exam.
Dr. Gerdes, my question to you is, in your opinion, does the 33% then overstate the occurrence of contamination if, in fact, those 1.1 and 1.3 alleles are not from contamination?
With regards to that specific strip, this specific bar, that might be overstated. That's why I did the analysis the way I did to look to the next one over, which is the run contamination. So if we can look at May specifically, I can explain how I confirm whether or not these are contaminated.
Incidentally, these percentages in your inclusion of those 1.3 and 1.1s, was that also true in the 31% in June?
That's why it's labeled strip contamination and/or artifacts. It's clearly labeled as that. That's what it is.
Objection non-responsive, Your Honor.
Sustained. Ask the question again.
Dr. Gerdes, when you calculated 31% for the month of June, did that include the 1.1 and 1.3 alleles that may not be from contamination?
Yes.
The 17% reported in July, did those also include the 1.1 and 1.3 alleles that may not be contamination at all?
Yes.
All right. Thank you, Doctor. You may resume the stand. Photograph. Now that the projector is back, I'd ask to be marked as People's 568, which I had previously shown to counsel.
Proceed.
Dr. Gerdes, showing you one more photograph. Does that appear to be another hybridization record photograph that you reviewed as part of your review of the strips at the LAPD?
If I could just check it?
Sure.
It does.
And that particular run was conducted, well, that reflects a certain hybridization record number.
Hybridization 101.
And do you have a Xerox copy of what's contained?
No, I have a photo.
And a photo as well?
Yes.
Your Honor, with the court's permission, I'd like to display this photo. for purposes of identifying this particular photograph, Dr. Gerdes, what date was this run conducted?
1/14/94.
So January of 94?
Correct.
And the analyst was whom?
Aaron Riley?
Now, this, and the confirming analyst was Colin Yamauchi?
Yes.
This was one of the strips that you looked at as part of your review of the LAPD DNA work?
This series of strips, yes.
What was contained on this series of strips?
The first 5 items are actually evidence items. Then there's a standard number 5, a negative control, and then another evidence item.
Okay, when you say the first 5 items were casework, that's casework but not related to this case, correct?
That's correct.
In other words, this is an example of your review of their work that included actual other criminal cases, but not this one.
That's correct.
Is that why it has a number that appears to be 93 dash and then a series of numbers?
That's a code number for a different case, yes.
And as part of your review, that type of number tells you that it's casework, correct?
Correct.
Instead of like CTS or known reference samples and so forth.
Correct.
Now, in this particular instance, the analyst, and there were 8 strips run in this instance.
On this particular page, yes.
Now, if we could focus in on the written results column off to the far right. That column and the first 5 strips, I'm sorry, are evidence samples again, correct?
That's correct.
The next sample, which is in, what would it be, number 6, is labeled standard number 5,
Correct.
and that would be a known blood from a known person.
Correct.
Or positive control.
It's a positive control, yes.
Below that is labeled neg control,
Yes.
and is that what's referred to as a reagent blank or cloth control?
That's correct.
And then lastly, is there another casework sample,
That's correct.
which looks like it has a number beginning with 89?
Correct.
Does that indicate the year of the case?
I believe so.
So is it the case then that the Los Angeles Police Department DNA laboratory would actually look at cases that were, for instance, several years old as part of their DNA typing?
Apparently that's true.
Now, off to the right, where all the results are written, there appear to be many different alleles noted for all the samples, correct?
That's true.
As part of the review of a run, an analyst wants to look at the negative control, for instance. Is that right?
Correct.
And is that the type of control that an analyst would look at first?
Generally, yes.
Or if not first, very close to first?
Yes.
Because that control is very important in determining whether or not a PCR run is contaminated.
Correct.
Now, in this particular instance, the analyst noted, as far as the negative control, the presence of what looked like 4 alleles, correct?
Yes. On a negative control, which again should have no DNA, there's a 1.2, a 2, a 4, and a 1.1.
Now, if we could move up to the appropriate strip, where the actual dots are noted, that would be the second strip from the bottom, Dr. Burns?
Correct. From the
And we'll see if we can place an arrow just so it's clear which strip we're referring to. That would be second from the bottom, Dr. Gerdes?
That's correct.
Is the arrow currently pointing to that particular strip right there?
Yes.
Now, that negative control should show no dots in any of the probes,
No,
correct?
it should be totally clean. There should be nothing there.
And we're seeing a 1 dot,
Yes.
a 2 dot,
Yes.
a 4 dot.
Yes.
Is there a C dot?
Yes. On my photo there is.
But faint, would that be a fair description?
Yes.
Is there a 1.1 dot?
Yes.
Similarly faint?
About the same as C.
Now, the 1.2, 1.34 dot, without getting into its interpretation in this particular sample, is showing a clear reaction,
It
correct?
is.
Is there a reaction in the 1.3 dot?
No.
And lastly, the all but 1.3, that's going to basically show a reaction if any allele is present other than the 1.3, right?
Correct.
So that's another sample that you use to interpret the results.
Yes.
Now, if we could go back to the actual results section, and just first before we do that, then this is a signal to an analyst that there is a problem with this run, correct?
Yes.
It's a clear signal, isn't it?
This is gross contamination.
All right, if we could return to the results column in the written portion and go to the far right, and that's fine as far as zoom in or zoom out. There is the appearance of many alleles in each of these samples, correct?
That's correct.
It's fairly easy to determine that there's contamination in this run, correct?
Yes.
And in fact, the analyst noted that contamination, correct?
They did.
correct that the controls worked in this instance in revealing contamination, correct, Dr. Gerdes?
In this particular case, yes.
And in fact, they clearly worked.
In this particular case, yes.
Dr. Gerdes, as far as the materials you received in this case, you were provided, I believe you described, materials relating to DNA testing by LAPD,
Yes.
Cellmark,
Yes.
and the Department of Justice.
Yes.
And did you review all of those materials?
I did.
You are also provided, and in particular, reports from each of those laboratories.
That's correct.
I'm referring to DNA work as well. As part of
Specifically,
reports.
yes.
Were you provided any of the serological reports, that is, the results obtained by conventional serology?
No.
Were you provided bench notes relating to the DNA work?
Yes.
Were you provided all of the x-rays or autoradiographs?
The majority, yes.
Are there some you're aware of that you were not provided?
Yes.
What about the D1S80 films? Or they're somewhat like autoradiographs in appearance, correct?
Yes.
Were you provided those?
Yes.
Were you provided photographs, for instance, of typing strips? And I'm referring to the casework itself in this case.
Yes.
Were you provided photographs of product gels, as they're called, where there's an evaluation of the presence of DNA and how much?
Yes.
Were you provided photographs, well, or other, let me rephrase that. Were you provided x-rays or copies of those x-rays of what are called slot blots that are another method of determining approximately how much DNA is present?
I have not seen the original slot blots from either the DOJ or from Cellmark. As far as the autorad itself, I've seen Xerox copies.
So you haven't seen any of the slot blots that quantitate.
I've seen the recorded results. I have not seen the autorad that goes with that other than a copy.
Does Cellmark record the actual amounts from a slot blot, or is the x-ray the data from which they interpret it and don't note it in a written document?
They don't note it.
So therefore, is it correct that you've seen no reports or photographs detailing the amount of DNA that Cellmark determines from a sample?
Not directly from Cellmark.
Have you received it from some other source?
From the Department of Justice.
Well, I'm referring
On
to
the
Cellmark.
same item.
I'm sorry, maybe I didn't make it clear.
It was related to me through this. I believe it was related to me through discussions with testimony by Robin Cotton, and I read those testimonies in which she specifically stated what the DNA amounts were on the items in question.
Were you provided materials about proficiency testing by all three laboratories?
Yes.
And did you review all of that material?
Yes.
Were you provided, and you've already described receiving and reviewing each of the validation DQ alpha strips at the Los Angeles Police Department, did you review validation materials from the other two laboratories as well?
I did.
Did you review the accreditation materials from Cellmark Diagnostics, that is accreditation by the American Society of Crime Laboratory Directors?
I've seen documents related to that, yes.
And were those documents specific to Cellmark Diagnostics?
Yes.
Were there also similar materials from the Department of Justice that you received and reviewed?
I may have, I don't recall offhand seeing the specific document on that.
You have described reading some of the transcripts in this case, that is transcripts of testimony?
I read the transcripts of individuals that related to DNA. I haven't read the transcripts of the entire case.
What witnesses' testimony have you read the transcripts of?
Mazzola, Fung, Colin Yamauchi, Gary Sims, Renee Montgomery, Robin Cotton, and I may have forgotten somebody, but basically anyone who dealt with either sample collection or DNA analysis.
That's a lot of transcripts, isn't it?
It is.
Can you approximate for us how many hours you've spent just reading those transcripts? Or days or weeks, whatever's easier.
Perhaps, all total a week or two time.
1 or 2 weeks to read the transcripts of each of those witnesses, all of those witnesses?
Perhaps a week or two, yes.
Have you received any videotapes? for your review?
I've seen clips of videotapes, but I've never received them myself.
By clips, do you mean on television?
Yes, on TV or played during the course of the trial.
As opposed to a videotape that you received and
I
watched?
did not receive any videotapes.
Are there any other materials that you were provided with respect to this case?
I believe you've covered most of them.
You reviewed all of those materials, correct?
Yes.
You made notes as a portion of your review?
Yes.
You compiled a chart?
Yes.
As far as your notes, how many notes, I mean, can you state it in terms of pages, how many notes you took? And I'm
What
setting
does that
aside the chart
mean?
with
I don't
raw
know what
data
that
on it.
means.
Yeah,
It's a
most of
good
my
thing,
notes were
though,
taken
apparently, right?
During the, I had 1 or 2 pages of notes on the lab site visits. I had perhaps a page or 2 involved in analyzing or looking at the strips for each particular area as far as just summarizing, and that's all.
You've used the term site visit. Site visit has a special meaning in science, doesn't it?
Well, it can.
What does it mean?
Well, that's what you would call, for instance, if you were applying for a grant from the NIH and they requested a site visit, that would simply mean they wanted to come and look at your lab and inspect it.
That's a fairly formalized procedure, isn't it, for an inspection of your laboratory?
Yes,
And in fact, that inspection can have serious consequences to the laboratory, correct?
that's correct.
A site visit is performed by unauthorized personnel, for instance, from a government agency, right?
Correct.
Is it your view that your visits to each of the laboratories in this case were site visits?
No, perhaps it's a misnomer. I visited the laboratory. I'm under no authority of any accrediting agency or anything like that.
When you reviewed the results and all of this raw data, did there ever come a question in your mind about how a result was interpreted or how a procedure was in fact undertaken by the analyst?
I was provided with all of the protocols from the laboratory, so I had access to those materials.
Well, what I'm asking, though, is other than from the materials, even if you reviewed all of those, were there any questions in your mind about how an analyst performed a particular task? Did that ever happen?
Based on all the information I have, all of those things we just discussed, no.
So from your review of the materials, you had no questions whatsoever?
No, and remember, I've seen these, with the specific example of Cellmark and DOJ, I've done other cases involved in those particular laboratories, so I'm familiar with their protocols and procedures.
And you felt that that was a sufficient familiarity so that you could review all of these materials from all of these samples and have no questions of the analysts whatsoever?
If you've ever seen Gary Sims' notes, they're extremely detailed. All you have to do is read the notes.
And that was, in your view, sufficient for you to be able to render all of your conclusions thus far in this case?
Yes.
Am I, Your Honor?
Uno más.
Protocols that you have described previously as being used in your own laboratory, do you always follow, or do your technicians always follow those protocols exactly?
In any laboratory, you have the protocol is followed as carefully as possible and exactly as possible. If there's any situation that occurs where that can't be the case, then the technician is instructed to ask the director whether or not a changes can be made and which changes can and can't be made.
Thank you.
All right, ladies and gentlemen, we're going to take our recess at this time for the day. Before we do that, I just wanted to bring one matter to your attention before we conclude today. About a year ago, when I first was assigned this case, I received a lot of unsolicited resumes from people who wanted to come work for the court, and I got literally dozens of these. And I got one in particular that I recollect because it looked interesting, but it went in the same place that all the others went, which is into the round file. This individual persisted and sent it again, and so I figured at least I would read it again more seriously, and it turned out that this person was a high honors graduate from Claremont McKenna College, which, as you know, is one of this country's finest small liberal arts colleges here on the West Coast, that she had scored in the high 90s percentile on the LSAT. And looking at her work experience, it was impressive, a number of things that she had done. And the thing that really caught my eye is that she had worked as a speechwriter for a member of Parliament in Great Britain. So I took her on as a volunteer non-law clerk, since she had not gone to law school yet. And I figured, if nothing else, I can at least have her go pick up my robe at the laundry and save me the time to do that. And she has been with us almost a year as a complete volunteer at no cost to the taxpayers of our county. And actually, as you know, she's probably saved the taxpayers thousands of dollars with all of the goods and services that she's gotten for you, all the free meals at the restaurants, all the entertainment, all the wonderful things that have happened. She's also been introduced to basic legal research by
That
Pepperdine
hair
Law
was
students who work for me.
amazing.
And, you know, her primary job was to keep you all entertained, and I think she's done a great job. She now leaves us to begin her studies at a prestigious law school on the East Coast, and I know that you join with me in wishing her good luck with her studies. We all know that given her demonstrated
Objection,
talents, that she
relevance.
will obviously be highly successful in whatever it is that she chooses to do in her career. And in fact, I suspect that in my years of retirement, my claim to fame will be that she was once my law clerk. And we thank you very much. All right, and now, having said that, please remember all my admissions to you. Don't conduct any deliberations until the matter has been submitted to you. Don't form any opinions. Don't allow anybody to communicate with you. Have a wonderful weekend. As far as the jury is concerned, we'll see you all Monday morning, 9 o'clock sharp. Dr. Gerdes, you may step down, 9 o'clock Monday. All right, you all have a nice weekend. All right, back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Cochran, Mr. Thompson, Mr. Scheck, people represented by Mr. Kellberg, Ms. Clark, Mr. Clark, Mr. Harmon. Jury is not present. Counsel, anything we need to take up before we invite the jurors to rejoin us to conclude the cross-examination of Dr. Gerdes?
Your Honor,
Mr. Kellberg, good morning.
good morning, Your Honor. From my attire, you may expect that I was not anticipating a visit to your courtroom this morning, and that was the case, except that I was informed by way of a communication between Mr. Yokelson of our office and Mr. Douglas of the defense late Friday afternoon that in the most recent witness list for this week, the defense has named Drs. Bodden and Wolf as, I think, witnesses or prospective witnesses 4 and 5. I had asked Mr. Yokelson on Friday, August 4th, to make a formal request to Mr. Shapiro for any report from either of these doctors. We have never received a report from either one of them. And this morning I spoke to Mr. Cochran, who indicated that there may not be a report. I pointed out that when Dr. Bodden twice has been retained by our office, he has always submitted a report. But setting that aside, I learned to try cases when this court, I believe, learned to try cases before reciprocal discovery, and so trial by ambush is not an unusual procedure by which one learns to do cross-examination. But if this is to be a search for the truth, and if there is to be the impact of the reciprocal discovery provision of the California Constitution, I think it's incumbent that both sides share their materials. In this regard, if there's not going to be a report, if they've made a tactical decision not to have a report prepared, that'll be the subject of cross-exam, but I'd like to see every note that these people have. I think it's important to remember. We know Dr. Bodden has been involved with the defense since at least June 17th because we have the picture of Dr. Bodden with Dr. Heisinger examining Mr. Simpson's hand, as I recall, one of the exhibits that's been marked. And so I would like whatever they have because I have no idea what they're going to testify to. I had a brief conversation with Mr. Shapiro about 2 weeks ago where he indicated that if one or both Drs. Bodden or Wolf were called, that it might be on a limited basis and he would have a report. Apparently that may be changing. Again, I'll cross-examine these people if I don't get a note and I don't get a report, but I don't think that the people's will for reciprocal discovery is advanced if, in fact, I do not stand here and make a request through the court to get what is, in fact, our entitlement under that California constitutional provision.
All right, thank you, Mr. Gilbert. Mr. Cochran. Good morning.
Your Honor, in this matter, we are very, very aware of our responsibilities under reciprocal discovery. I think you, I, and Mr. Kellberg all learned how to try cases under the old system, and we've adjusted to the new system, obviously. That's part of being a lawyer, I suppose, and being fairly intelligent is the ability to adapt. The problem is Mr. Shapiro is not here and may not be here today. He'll be handling any witnesses that we call from a forensic pathology standpoint, and he's mindful of his obligations. You know, it's an interesting argument. I just like to point this out, Your Honor. If witnesses don't normally write reports, we don't have to ask them to do a report. In this case, several times we said, write a report so we won't have any problem. Then we still get whipsawed. I mean, you can't win. And people should understand that. You can't win. If we ask to get a report, or they don't normally even write a report, then the prosecution said, well, gee, that report came late, and we want to delay. So, you know, you cannot win. Let's just make that clear. And the search for truth works both sides. He said, North Carolina, it's everywhere, and we want to search for truth also. But let me just say this. If there are notes, he's entitled to notes. I can tell you they don't normally write reports, but if Mr. Shapiro makes the decision, as we've done with the other witnesses, say, write a report so we don't have any problems with these people, then we'll do that too. But I can't say he's not here yet.
Right.
But we will do.
We'll wait for Mr. Shapiro to write.
Yeah, and Judge, if he doesn't come, he may be working with him. I will speak with him and get word and report it back. And Mr. Kellberg, we can let him know at his office.
And, Your Honor, Mr. Cochran was kind enough to identify the last name on this witness list, who none of us was familiar with, J. Uko, U-K-O, and apparently this is Dr. Uko, a pathologist from Buffalo. My request goes to Dr. Uko as well as Drs. Bodden and Wolf. And I have nothing to say about North Carolina. I'm not trying to make a pitch for anything other than the limited responsibilities I face at the end
All
of
right.
this week.
Well then, Mr. Kelberg, why don't you see if you can't contact Mr. Shapiro?
Or I'll do it for him, Your
All
Honor.
right.
And
Okay.
I'll give Mr. Cochran my office.
All right. Thank you, counsel. All right, Mr. Clark, we ready to proceed?
Actually, two items, if I might bring them to the court's attention. The first relates to the grant proposal, and it's my intention, the court may recall that that proposal was faxed to this courtroom. Having reviewed that material, there are two areas of inquiry that I wish to make, but not as to the specifics of the technology contained in it. I wanted to bring that to the court's attention before I launched into that.
Perhaps he could, Mr. Clark, at sidebar or in a sealed record can indicate what that is so that I can just...
What's the nature of your inquiry, Mr. Clark?
Approaches in the laboratory of the witness. I can't be more specific, but I'd like to do it outside the presence of the witness.
I'm just
All right.
have those proprietary...
Dr. Gerdes, why don't you wait outside, please?
Your Honor, could we approach on this because I just have that proprietary...
Mr. Clark
concern.
indicates it has nothing to do with the particular topic, just the technique involved.
Correct. The two areas of inquiry that I wish to make is there is reference in the proposal and a description of this witness's laboratory as being a laboratory that uses primarily, quote, home-brewed, unquote, methods, as opposed to kits. And I think that's an area that's significant in the context of this witness's prior testimony. So that's a fairly brief and narrow area. Actually, it's probably a couple of questions. The second area relates to a further description of the laboratory as a progressive reference laboratory that rapidly seeks to implement new DNA technologies. And I think that obviously is relevant to this inquiry as well. So my intent is not to get into the specifics of the proposed technique whatsoever.
All right, thank you for the warning.
The second relates to discovery. And in the same vein as Mr. Kelberg, I'd like to give the court a very brief history of what's occurred since last Monday. Either Tuesday or Wednesday of last week, I was provided by Mr. Scheck 6 pages of Dr. Gerdes' notes. At the noon recess on Friday, the court may recall Dr. Gerdes referred in his testimony to further notes that he had in his possession. And at that time, per Mr. Scheck, those further notes were, quote, provided long ago to the people in discovery. Mr. Blazier indicated at that time that that was not the case and that in fact they were not provided to the people because they were never asked for. Now I think that's an important comment, particularly in light of Mr. Cochran's comments just a few moments ago, that the people are entitled to notes. And so here's a situation in which there were clearly notes that existed. Dr. Gerdes had them in his notebook. The defense was apparently aware of them, and yet we were denied discovery of them until Friday at noon of last week. Now copies were made of those notes. They contain some important information that I will further address the witness about. We're not seeking a remedy as to this witness at this point, but I think it's important that that event be known, particularly in light of what Mr. Kelberg just stated, and also in light of what will be the approaching witnesses, at least by the information that we received last Friday as to the next DNA witnesses. It's my request that with respect to those DNA witnesses, and there are at this point 3, apparently to follow Dr. Gerdes, that Mr. Harmon would ask a brief moment to address the court about obtaining discovery of those materials immediately, if that's acceptable to the court.
No, I think you just made the request on his behalf. I don't think you need to add anything more to that other than to name the individuals.
Well, at this point, I think I would like to add that we have been notified that those individuals are Dr. Speed, Dr. Mullis, and Dr. Shields. And at least in terms of any witnesses, particularly those who may involve statistics, that frankly it's a bit inconceivable that there aren't notes about calculations of population frequency data related to this case. And yet at this point we've received 0.
Just the first matter is that I'm glad Mr. Clark raised this issue. Mr. Blazier and Mr. Douglas, as the court recalls, were handling the discovery and showed the court various notes and had made a legal determination, since they're the California lawyers, under the Hines case as to which notes were turned over or not. And the 2 sets of notes that we're talking about is that Dr. Gerdes made some handwritten notations when he did his lab tour, and pictures were taken when all the LAPD people were there and they took the same pictures and they were there on the same tour. I had mistakenly believed that those notes had been turned over. That was just a mistake, and they were given to them at that time. I was informed by Mr. Blazier that those were in the category of notes that are turned over when the witness testified. They're not, they were not notations of any reports or calculations or examinations that he had done. I had made sure that the charts, the contamination analysis, the unexpected allele analysis has been turned over months ago, along with Dr. Gerdes' report. The other notes that Mr. Clark is referring to are handwritten notes that Dr. Gerdes made that are really inventories of what is contained in the raw material. In other words, he has a series of notebooks here that contain some but not all of the data, and on the cover page of each section, he has notations about what is, it's like a table of contents as to what's in the other materials. And I would just note in passing that at various times when I approached the witness stand when Gary Sims was testifying, I know it was true of Renee Montgomery and Mr. Yamauchi, other witnesses, they had similar kinds of table of contents notes in terms of the materials and other notations to themselves that I suppose I now understand under the rules I could have asked for at that time, but I saw what they were. So those are the nature of those notes, and I just want to make that clear because I don't want to get into any trouble on discovery obligations. I'm relying on the California lawyers here who have been to the court and have gone through these materials.
Well, at this point, since Mr. Clark is not asking for any particular sanction, let's not waste a lot of time.
I just wanted to make clear to you exactly what the nature of this was so that
Now, having said that, what about the next three?
well, Mr. Neufeld will address Dr. Speed, who he's going to put on, and as far as and he's actually putting on the other two witnesses. And at this time, we have nothing that no reports and no notes in the nature of anything that we think we have to disclose at this time.
Right, even in the nature of statistical calculations?
No,
or
there's no. I can, unless they're doing something now. There's nothing in the nature of statistical calculations that Dr. Speed is doing. I feel quite certain of that. But again, that's Mr. Neufeld would know better than I, but I feel fairly certain of that.
All right. Deputy McNair, let's have the jurors, please.
Before he asks any questions about the term home brewed, that we can find it in the report he doesn't obtain.
All right, the record should reflect that Dr. John Gerdes is on the witness stand undergoing cross-examination by
Again.
Mr. Clark.
He's on the witness stand.
Good morning again, Doctor.
Again.
Good morning.
Wait, is he in a
Doctor,
different
you were reminded,
outfit?
sir, you were still under oath, and Mr. Clark,
Yep,
you may
we're on
conclude
August
your
7th.
cross-examination.
Thank you, Your Honor.
Hold
Morning, ladies
on.
and gentlemen. Morning, Dr. Gerdes.
Good morning.
So,
Dr. Gerdes, you recall testifying last week that at the LAPD laboratory where DNA
Hold on.
extraction is done, that the laboratory does not use a laminar flow hood.
Yes, that's correct.
Now, you visited the laboratory, is that correct, in December of '94?
son of a gun.
Yes.
And you took a tour of the
He's
lab? Is
here
that a fair
until the
description?
end of this
Yes.
And that tour included the
And
DNA
then-
laboratory, correct?
today. So it's 2
Yes.
hours.
All right,
But
Your
we're
Honor, with
sped
your
up.
permission, I'd like to display to the witness Exhibit 1301, which is a
But I can't tell about tomorrow. But Sheck is up tomorrow. I can see Sheck is up. So it's possible he's going to be on tomorrow. And August 7th, part 3, the next day, I can't tell from the thumbnail. It just shows OJ. And then August 8th, I can't tell. It just shows people walking around in the courtroom. But I can see on August 8th, part 2, the last part, the other lawyer is up, and I can't remember his name. So I'm pretty sure by that time we're done with him. So at most, 1, 2, 3, 3.5, or 2.5 to 3.5 more streams of this guy.
photograph of the laboratory. Dr. Gerdes, can you see that from that angle?
Yes.
And in particular, with respect to this photograph, does this photo show the hood that you described during your testimony in the DNA lab at the LAPD?
It does.
Now, as far as your tour of the laboratory back in December, did you take notes during that tour?
Yes.
And in fact, did you create rough, let's say, diagrams of various locations at the DNA laboratory at the Los Angeles Police Department?
Yes.
Your diagrams included the area where DNA is extracted, is that right?
Yes.
As well as where the hood is located?
I believe so, yes.
In terms of your keeping those notes, did you attempt to be as accurate as possible, setting aside exact scale?
Yeah, there was no scale, and it was just to give me a rough idea so that I could go back to those and recall what I'd seen.
Now, did you have occasion to provide to the people last Friday notes that you took, including a diagram or diagrams of this particular tour?
Yes.
All right, Your Honor, I'd ask to have marked as people's next in order a single page, which I'm showing the council.
569.
May I approach the witness, Your Honor?
You may.
Dr. Durkin, showing you People's Exhibit 569. Does that appear to be a Xerox copy of one of your notes?
Yes.
And is that, in fact, the note that contains a rough sketch, a rough diagram of the extraction area at the Los Angeles Police Department?
Yes. These notes were taken on 12/19, the first visit.
December 1994?
Correct.
Your Honor, may I display a portion of this note also?
You may.
Now, I don't know, Dr. Gerdes, can you see the screen from there?
Yes, I can.
Does this appear to be the lower portion of that single page of notes, People's Exhibit 569?
Yes.
And is this your rough sketch or rough diagram of the DNA extraction area at the LAPD?
Yes.
Now, there appears to be a fairly long rectangle, comparatively speaking, in the middle of the diagram, which is, I'm not sure I can really read it, but it looks like it has two words. Is that right?
Yes, it says sorting
And
bench, I believe is what it says.
just
right
to
there.
the left of where the arrow is located?
Yes.
All right, and then off to the left of that long rectangle, towards the top, there appears to be a square with the term hood written inside.
Yes.
Now, off to the left of that, what are the other two words that precede the word hood?
It says laminar flow.
Meaning what?
Well, at that time, I hadn't really noticed that this wasn't a laminar flow hood. I put down laminar flow, and I didn't really realize until the second visit that this was not a laminar flow hood.
So upon your initial visit to the Los Angeles Police Department, you recorded in your notes laminar flow hood to describe that particular hood.
Yes. That's incorrect.
Was that a mistake?
It was something that I checked later on and found to be a mistake, yes.
Now, Dr. Gerdes, you testified last week that in your opinion, DQ alpha PCR typing is not ready for forensic testing, correct?
In my opinion, yes.
And that continues to be your opinion today, correct?
Until adequate controls are incorporated to control the contamination problem, that continues to be my opinion.
And it's your opinion that it should not be used for either including potential donors of DNA or excluding them? Oh.
Yes.
Are you familiar with a method of typing what's called mitochondrial DNA?
Yes.
Does that use PCR also?
It does to produce a product that's then sequenced.
Okay, and without getting into great detail, does that method involve, after amplifying a sample, basically looking at the pieces of DNA information, these letters, A's, T's, G's, and C's one by one?
Yes.
Is that a method that is in place in forensic laboratories around the world?
Not on a routine basis.
In your opinion, is it ready for use in forensics?
No.
You referred last week to a number of scientific publications discussing DQ alpha as, and I think you used the term demonstration papers.
In my opinion, yes, what they are, yes.
Now, you have testified for approximately the last 5 years that PCR DQ alpha typing should not be used in forensics, correct?
I've been very consistent in expressing my opinions about contamination and my concerns, yes.
And that's been for about 5 years?
Yes.
And you've actually come to courtrooms like this and testified the same way as far as that particular opinion for
That's-
the last 5 years?
That's true.
As far as your own laboratory, is it correct that most of the methods that you use in your lab in Denver are methods that don't involve the use of kits?
No, that's not true.
Are most of the tests that you use tests that do involve the use of kits?
Yes.
You mentioned chlamydia. That's one of the tests for a sexually transmitted disease that you use a kit that's actually manufactured by Roche, correct?
That's correct.
What are the other tests that you use a kit in?
Oh, well, there's the vast majority of the testing our laboratory does. Testing for antibodies for HIV, HTLV, I can go on and on. It's probably a page-long list of things, most of which we do use FDA-approved kits.
Are any of these kits manufactured? Well, let me rephrase that. Were any of these kits developed in your own laboratory?
No.
is it then your testimony that most of your methods, well, let me strike that, rephrase that if I may, Your Honor. As far as a grant proposal that you described during your direct examination, do you recall that testimony?
Yes.
This related to a grant that you have fairly recently received, is that
Yes.
right? That related to a particular technique developed in your laboratory, is that right?
It hasn't been developed yet. That's what the grant is for, is we're proposing to develop that technology.
So the grant is basically you're receiving, your laboratory, receiving money to develop a particular technique.
Yes.
As far as that grant, does this process involve your laboratory submitting a proposal to a government agency?
Yes.
And then I'm sorry. And the government agency then uses that proposal to decide whether or not to grant your laboratory money to look at this proposed technique.
That's correct.
As part of that proposal, are you required to describe a number of different things in this application for money,
Of course.
including the technique that you wish to try to devise,
That's true.
as well as information about the laboratory,
Yes.
as well as information about the individuals who would be involved in developing this technique?
That's true.
Dr. Gerdes, in this particular grant proposal, are you familiar with it?
Of course.
And you've read the entire document?
I wrote it.
You wrote the entire document, all right. Isn't it true that in that document, you state in reference to your laboratory, most of our testing could be described as home brewed as opposed to commercial kits?
The witness be shown the entire paragraph, showing what page it is of the...
Dr. Gerdes, if I can refer you to what appears to be page 31 of the proposal.
What part of this page are you at? Oh, here I see it. Okay.
That statement that I just read, was that a statement that you wrote in that proposal?
Yes, it refers to the fact that in our laboratory we do go through some research and development, and then it's progressed on to testing this routine, and it has to do with our research and development department. It has nothing to do with the testing menu that we offer at the present time, which is what you asked me initially.
Well, is it then correct that most of the testing methods in your laboratory are, quote, home brewed?
Well, most of the newer methods, this is talking about the next generation, if you will, from our laboratory. Most of what we do at the present time are kits that are FDA approved. What we hope to do is to move into the field of development of new diagnostic technologies, and we have been involved in that process since I've been hired. That's one of my jobs. But we are not yet using those types of tests for routine testing.
What does home brewed mean?
It simply means that you're developing the test yourself as opposed to buying a kit.
You've described the chlamydia test kit as FDA approved, correct?
Correct.
What are the other testing kits and casework that are FDA approved in your lab?
For DNA, or?
Yes.
That would be the only one for DNA. All of the kits that we use, other than that particular kit, involve serological methods.
Which don't involve testing DNA.
Correct.
Can I have just a moment again, Your Honor? Now, as far as degraded samples, Dr. Gerdes, and we spoke about that last week, your concern about the reliability of results obtained using PCR-based testing in forensics is based really on the nature of the specimen. In other words, the fact that it's a blood stain that may have been on a sidewalk as opposed to blood removed from a patient in a hospital, right? Is that correct?
That's one of the aspects, yes.
Now, as far as this use of DQ alpha testing, are you familiar with its use on cases in which defendants have been, for instance, in prison for a number of years?
Yes.
And in fact, DQ alpha testing has been used to determine years later that a person may have been innocent of a crime. Is that correct?
It's been done for that, yes.
And in fact, inmates have been released from prison as a result of as a result of typing results obtained by using this PCR DQ alpha method.
That's true.
Those cases may involve cases that occurred years earlier. Is that correct?
That's true.
Your concerns about degraded samples would apply equally to those cases as well. Isn't that true? Where the samples may be years old.
Yes.
Is it your view that under those circumstances that inmates should not be released from prison as a result of DQ alpha typing conducted what may be years later?
I think you have to take every case by case in terms of how much weight to put on that or whatever, but my position has always been consistent that until you have more adequate controls, and in specific in those kinds of samples where they're old, degraded, and in small quantities, this technology has a tremendous risk of error.
As far as the samples that were not amplified and typed at the Los Angeles Police Department, and I asked you a number of questions about that last week, correct?
Excuse me, go ahead.
Sure. As far as the samples that were not amplified and typed, in other words, they weren't subjected to this PCR process and typed at the LAPD, do you recall that?
Yes.
Isn't it true that independent laboratories who reach the same results adds confidence to the results themselves? In other words, the layer or level of confidence that an analyst can have in the accuracy of those results.
It will give you confidence from that step on, but what happens in the previous steps can't be cross-checked.
Isn't it correct, Dr. Gerdes, that if you work in two separate labs and try and come up independently with the same result, then that's always going to be a confirmation of the test and give you more reliability?
Only if both labs handled totally those specimens independently. That means they're collected and sent, as we described earlier in the clinical situation, to both labs and are never exposed one lab to the other.
Haven't you previously testified to what I just stated, Dr. Gerdes?
I may have, but that was prior to more recent cases where it's become more and more obvious that there are problems early on.
Strike non-responsive, Your Honor.
Sustained. Last part of the answer is stricken and juries to disregard.
Dr. Gerdes, haven't you testified previously
New
to what I
court
just read to
rule.
you?
Yes.
If he doesn't respond correctly to a question, boom, right in the throat. And then he'll start responding correctly. We learned that in the 80s. In the 80s, we learned that if you don't answer questions correctly, boom, right in the throat. The nuns can't have been wrong.
Samples 48, 50, and 52, the bloodstains at Bundy, were swatches sent to different laboratories, correct?
Correct.
As far as Cellmark is concerned, and I'd like to shift your attention to known samples, or if we use the term reference samples, can that indicate, as far as these questions, we're talking about known samples from the people who may be involved in a case, all right?
Correct.
Referring in this case to Mr. Simpson,
Yes.
as well as Nicole Brown and Ronald Goldman.
Yes.
Isn't it correct that when Cellmark conducted its testing on the known samples, they were done blindly?
They were coded, yes.
And by coded, what do you mean?
They were given a code number when they arrived at the laboratory, and then the technician would type it from there.
Well, in
So
addition,
blinded, if you want to call it that, yes.
in addition to having a code number, isn't it correct that the actual known reference samples weren't labeled for Cellmark's purposes as to who of the three people they came from?
As they received them?
Yes.
I don't recall if that's the case. I know they were labeled with a code name, but I'm not sure if they had also the information as to who they were from. I'd have to double check.
All right. Do you have information at your hand that would be able, would help
Perhaps.
you answer that question?
Perhaps I do. That appears to be correct. They were labeled with a code name, and it doesn't have who it is next to it.
So Cellmark was in fact given these known samples, and they were coded C1, C2, and C3, weren't they?
That's correct.
And they were not given information about which sample was Mr. Simpson's,
That's correct.
which sample was Mr. Goldman's,
Correct.
and what sample was Nicole Brown's.
Correct.
In your opinion, is that an important step?
I think that's the way to do it, yes.
Isn't it also correct that as far as the DQ alpha types that the Department of Justice typed, that those reference samples were done after most of the evidence was typed?
I believe that's true.
And in fact, isn't it true that the known samples were not typed until after there were PCR results on several of the Bundy blood drops at the Department of Justice?
I don't recall if that's specifically the case, but that's possible.
After several of the stains from the Bronco were tested by the Department of Justice?
That's possible.
Well, isn't it true?
I don't recall that. I can look it up if you'd like and try and look that up.
Is that something you think you can find in your notes?
I think I can.
All right. Just curious.
That appears to be the case, yes.
Those reference samples were typed after, for instance, one of the blood trail at Rockingham was typed, one of those drops
That's correct.
also.
That's correct.
As well as most of the samples on the glove,
Yes.
as well as most of the samples on the socks as well.
At DOJ, yes.
In your view, is that also an important step to take, to type those reference samples after evidence is typed?
I think that was appropriate.
Now, I'd like to return, if I could, Dr. Gerdes, to the fact that in your laboratory, you develop methods for use in DNA typing in your lab, correct?
Correct.
Part of your function at the laboratory, and you're, I believe you said you're director of the research and development arm of the lab,
That's one of the titles I have, yes.
and in that role, as far as the research and development role of the laboratory, you try to develop methods that other laboratories can use, correct?
Yes.
And in fact, your proposal for a grant is one such proposal, to develop a specific technique to type DNA that other laboratories can use.
Hopefully, yes.
You want to make sure that your techniques operate properly before they're used, for instance, in clinical casework.
Of course.
That's absolutely essential, isn't it?
Of course.
You also want to be able to market or sell these methods as quickly as possible. Isn't that correct?
Yes.
Is your laboratory committed to rapidly implementing DNA technology to diagnostic testing?
Yes.
And in fact, you want to get these new techniques out there and marketed as soon as possible, correct?
We have a projection as to how long this will take. The technology we're describing is so new, it's going to take 3 to 5 years before we even confirm the technology itself. So we're really not talking about marketing for that many years.
Well, Dr. Gerdes, isn't it true that your laboratory is committed to getting these newly developed techniques into the clinical laboratory as quickly as possible?
We would like that, yes.
And in fact, that's what you told the United States government as far as your grant proposal, didn't you?
Yes.
As far as, and we've talked about PCR as one technique, there's also the technique of RFLP that you discussed in your direct examination, correct?
Yes.
Can we call those different methods or methodologies? What word would you feel comfortable with to describe that they're two different techniques?
Different methods is fine.
Isn't it correct that a consistency in result, that is, that a result is giving the same answer from both PCR testing as well as RFLP testing on the same sample, is one measure of the accuracy of the PCR technique?
It does tell you some information. The RFLP is a more discriminating test, so you would expect that there would be a number of occasions where the PCR would include someone and RFLP would exclude them.
Okay. And that's certainly one characteristic of RFLP typing, that it's more powerful in telling people apart, correct?
Correct.
If you saw PCR results that, for instance, exclude someone, and from the same sample an RFLP result included the person, that would give you great pause for concern about PCR typing, wouldn't it?
Not necessarily. Depends on how many probes, and in any genetic analysis you look at multiple markers, and once you find an exclusion, If it's confirmed especially, then you have to believe that.
Well, let's make it more specific. Let's say that on a particular sample, you saw a 5-probe RFLP match. That would be powerful evidence of who that sample came from, wouldn't it?
It would.
If you saw a PCR result on the same sample that revealed results that excluded that person, wouldn't that give you concern about the PCR result?
In a forensic setting, yes.
So therefore, if there is consistency between the RFLP results and PCR results, doesn't that give you greater confidence in the PCR results?
It can.
Well, haven't you testified previously, Dr. Gerdes, that you have no problem with the RFLP technology?
I have.
And you've testified in this case that you have no problem with several of the RFLP matches in this case. Isn't that right?
That's right.
Isn't it in fact the case that if there's an RFLP match on a sample, in your opinion, that validates the PCR result on that sample?
It can.
Haven't you previously testified that it does?
I probably have in the past, yes.
Isn't it true that if there's an RFLP match on the same sample that a PCR result is obtained, that RFLP match confirms the PCR result on that sample?
Of course, you have to look at the samples. Even in RFLP, there are going to be circumstances where those kinds of results need to be looked at with suspicion in terms of whether it's a mixed sample and the same sorts of issues that we discussed earlier in general in terms of DNA technology and forensics. So you can't make a broad, blanket, general statement like that. You need to look at the circumstances for each item, even in an RFLP test.
Dr. Gerdes, haven't you previously testified that if you get a PCR result on a sample and you already have an RFLP result on that sample, that RFLP result confirms the PCR result?
Assuming there are no difficulties or suspicions about the nature of the sample or mixtures or other complications like that.
Isn't it true, doctor, that if you cross-check the PCR results and RFLP results on enough samples in a given case, that is a significant method of validation?
I would call it validation.
Haven't you used those exact words, Dr. Gerdes?
I believe maybe 3 years ago I might have.
And in fact, those words that you used were just as I stated to you, were they not? That if you cross-check the PCR results and RFLP results in a given case on enough samples, that is in fact a significant method of validating the accuracy of the PCR results.
I probably said that, but you have to look at the context around then. I'm sure I also said that you have to look at the sample and the things that I've talked about here.
When you said it, did you mean it?
Yes.
Have a moment, Your Honor.
Okay, that was a good timing, sir. That was good timing. Whew. We've been through some boring content during this OJ trial, but the last couple days have taken the most out of it. And you know why I think it is? I know why it is. Holidays. Like our viewer count for the live streams have been lower for the last couple live streams because of holidays. People being busy, people traveling, visiting family, all that. But just so you know, replay, the numbers are fine on replay. They actually come back and watch it later. They just don't join us so early in the morning. And that is absolutely fine. If I did this alone every day, that would be fine. Because it's very early in the morning. Well, not anymore. It's 9 o'clock now. But we're going to finish him tomorrow, I think. Question mark? Maybe. Hopefully. So I did download one day of August last night and started to beep out the words. So I'll be ready, because we are in August right now. I'll be ready when we get there with a bleeped out clean versions of, I'm probably going to leave the swearing in. I'm just going to take that offensive word completely out. And it's possible we're going to hear it once or twice before then. We've already heard it once or twice. There's nothing I can do about that. It happened during the OJ trial. So, I hope that you guys have a great day. And I will speak to you again real soon. Alright? Bye, guys.